Good afternoon. Call back to order the meeting of the Sacramento County Board of Supervisors. Would the clerk please call the roll?
Supervisors Frost.
Here.
Natoli.
Here.
Peters.
Here.
Cerna.
Here.
And Kennedy.
Here.
You have a quorum.
Next item, please.
Item 86 is the appeal of the decision of the hearing officer's denial of renewal of a general business license and revocation of a business license. The appellant is Michael Liu with the Golden Dragon.
I can introduce this item. This is an appeal from the April 4th, 2019 hearing officer's decision revoking and denying renewal of the general business license for the Casa Linda Motel. As the board will recall, this was originally heard on May 21st, 2019. There were some questions that arose during that hearing because of evidence that the appellant presented at the hearing. So the board chose to continue the item to allow time to determine what the current status is of the violations. So my understanding is there has been a fair amount of work done since that hearing on May 21st. I know a number of departments met in early June. The property's been inspected again, and we're back here today again with a recommendation from business licensing for denying the appeal. We talked about this last time. Under the county code, there are 3 different ways that the board can proceed on these sorts of hearings. The options are the board is authorized to deny the introduction of evidence and decide the matter after hearing oral argument only. The other option is the board can admit supplementary evidence with respect to the challenges on particular findings, or the board can reject the findings and conclusions of the hearing officer and conduct a de novo hearing. At our last hearing on May 21st, the original thought was that we were going to be recommending just hearing the matter on oral argument, but the appellant did present additional evidence, and so now the recommendation is, and I agree with this, that the board should choose the second option, which is to admit supplementary evidence and then proceed with the hearing. I do not recommend that the board do a de novo hearing. That would basically toss out what the hearing officer did and start over, but I think that the second option of allowing supplementary evidence is appropriate in this matter.
Okay. Supervisor Natoli.
Yeah, just before we embark on the hearing, then thanks, Krista. That helps set the framework for the, the hearing we're going to have here. But I wanted to be clear. The written report, the last details in here references June 5th. To your knowledge, has there been any additional follow-on by any of the county departments since that time? It was a coordinated inspection and.
Right. I don't. My understanding it was June 5th, but I think somebody else from either June or perhaps
okay. So,
from
but as far what we have here is the most current information as it relates to any inspection of the property.
That is my understanding.
Okay. All right. I just want to be clear about that. And then one other thing, I know that subsequent to the last hearing, obviously we've gotten the correspondence to the staff report. There was information at our desk here this afternoon, and if folks from the general public are here, are they able to weigh in on this? Is this a hearing where folks, if they have a concern either about what's being proposed relative to the revocation and denial and or either support or oppose that action, they're able to speak at the conclusion of the...
Public testimony can be taken.
Okay. All right. Thanks, Mr. Chair.
Thank you. All right. Now it's appropriate to hear from the appellant. Are you interested in presenting?
Good afternoon, members of the board. My name is Abraham Liu. I am the son of Michael Liu, the owner-operator of Casa Linda Motel, doing business under Golden Dragon 888. The county has recommended that the revocation be upheld, and primarily, we would ask the board to consider that we've made considerable progress in addressing each of the concerns that the county has listed, specifically in the business licensing department. Ms. Kathleen Brown's report on June 5th did indicate that with the exception of a telephone issue, everything else from her previous inspection has been addressed. And on the telephone issue, there there's an area up for sort of discussion in terms of how many telephone lines are necessary, how many telephone lines are required for 17 units. We've actually polled similar properties, similar businesses in the area, and found that they have a similar ratio of 1 line per 10 rooms, or a little over 10 rooms. But it is something we are willing to consider should the board feel that it's necessary. As for the inspection conducted by Mr. Parker, we feel that there's a wide variety of issues discovered that have been addressed by the pending building permit. So there are open building permits right now to make necessary changes to the electrical, gas, and water heater systems that Mr. Parker did discover. And in the other issues, primarily things like we feel that they primarily address the age of the property, which is quite old, but we are willing and committed to addressing each and every one of the issues that Mr. Parker has noted on his report. Lastly, we would like to point out that we have been we have successfully we have successfully closed out issues that Mr. Wycliffe's department has conducted. So I don't feel that in any circumstance we've been neglecting issues that have been brought to us. So we hope that the board exercises its power and consideration to allow us to continue to operate the business. We feel that we can be better operators than previous owners. We've taken care of a lot of the issues that they've neglected. We've worked with the county to address each of the issues, and we hope the board hopefully doesn't want to see Casa Linda as a vacant property, dilapidated lot of that nature. So we hope the board gives us the opportunity to continue working with the county and operating. Thank you.
Thank you. Are there any questions? Mr. Natoli?
Well, Ms. Peters had her hand first, so.
I didn't.
I didn't either, so. But you,
I have a couple questions. In our updated staff report, it says on June 5th, 2019, there was an inspection by the code enforcement, the sheriff's department, and state contractors license board, et cetera, and there's still numerous violations, as stated here, but not limited to exposed electrical wiring in lighting receptacles, damaged electrical panels with exposed wiring, broken, rotted, split and buckled walls and roof coverings, heat and air conditioning units improperly installed in a state of disrepair, holes in walls, missing broken shower tub hardware, and it goes on, including bed bugs and visible mold. So I'm wondering, you've had this property for 3 years, I think it was 2016, and you've been under pressure to improve it for over a year, and so can you explain these things? Why would you not notice those things and have had them fixed, particularly when you knew there was an inspection coming?
Well, ma'am, we have been fixing issues that have been brought up, right? So in terms, typically there could be some discussion with the inspection officer. Like, for example, on the issue of bed bugs or cockroaches, we have an inspection report conducted recently by a licensed pest inspector.
Recently after the June 5th inspection or before?
Yes, ma'am, afterwards.
And what does it say?
It says the pest inspector did not find any evidence of either cockroach or bed bug infestation.
What about all the other items, damaged electrical panels and roof coverings and holes in walls and?
So for a lot of the large structural issues, we do have a building permit open. It's undergoing plan review with the county right now. So once the plans are approved, then we will be making those fixes.
So is there anybody here from building that could speak to all of these items being corrected in the building plan? Oh, hi. Okay, all right. Thank you. I was looking for you over there. I didn't see you, June.
Change places today. Good afternoon, Supervisors. So I am here on behalf of multiple county departments. June Powell's-Mays from the County Counsel's Office. And first I will speak to some of the issues that were raised by appellant, if you don't mind. They ask that you consider the progress that they have made. And while I understand that request, you also have to consider the length of time they have owned this property. And they were issued their business license in January of 2016. Conditions were imposed on that license in June of 2018. Since the time that they have owned it, unfortunately, it has maintained its presence as a problem property. The fact that they pulled similar businesses and they too are in violation should absolutely not be persuasive for this board. It does not change the fact that they did not meet the requirements that they were supposed to meet. Open building permits also shows that they submitted an application, but it does not mean that the permit has even been issued. And so no work can begin until a permit is issued. The bottom line here is that the county code authorizes the revocation and the denial of business licenses if conditions imposed on the license are violated. Also, if nuisance code or zoning code or building code or dangerous building code violations exist. As of April 4th, 2019, a hearing officer found that multiple conditions on the license had been violated and that there were open code enforcement and building inspection cases. Unfortunately, as of June 5th, 2019, the same was true. There were multiple violations of the conditions on the license, including the inoperable telephones and the fact that there were open code enforcement and building inspection cases. It was made clear in the report that's prepared for today, as well as the attachments, that the building code violations that were initially found were still in existence at the June inspection, and more violations were also found. The same was true for many of the code enforcement violations and dangerous building violations. And so based upon that, we are requesting today that you would deny the appeal. And let me just backtrack one moment and say, we do not have a perpetual correction period. So property owners who are given notices of violation, whether it's a zoning code violation or a building code violation or a substandard housing violation, are expected to comply within a finite period of time. And unfortunately, the appellant here wants a perpetual correction period, and that cannot be, as it is not authorized by the county code. So we are asking today that you would deny the appeal, that you would adopt the hearing officer's decision as of April 4th, and that you would also make an additional finding that the conditions on the license still remain in violation and that there are open building and code enforcement cases.
So how would they, if we were to do that, then the motel would be closed?
Yes.
And would they then have to go back and fix everything as if, and then start over in the licensing?
They certainly could.
If that's what they wanted to do.
If they wanted to maintain the property, but it's my understanding that it's an escrow to be sold.
Okay, thank you.
Mr. Natoli.
Yeah, thank you, Madam Chairman. Thanks, June. I wanted to ask Abraham a couple questions if I could, so if you might just stand by for a second, please. Abraham, again, I see the letter and you spoke to it here on behalf of your family, but when I look at the list, the most recent one, recognizing obviously that there's been an attempt to address some of the issues, and whether or not there's a pending building permit application. Some of these things are pretty serious. I mean, they didn't just happen overnight, and others have, happened. Obviously, you have damage from tenants, but as Ms. Peters read, the general summation, and when I see the inspection checklist, I trust you got a copy of this, or you as a family did, it makes pretty clear in that notice, and this is the one from June 5th when Mr. Parker was out there. It says pretty explicitly, it says, please take note that the county has found that the dwelling and/or property at the above location is substandard and constitutes a public nuisance. Each of the conditions noted on this inspection checklist is a misdemeanor violation of the Sacramento Housing Code and constitutes a separate offense for each and every day during any portion which a violation is committed, continued, or permitted. And they inspected 17 of the 18 units, I guess the 17 that are rented, and they cleared none of them. I guess I just, beyond the building being old and maybe some of this being roofs that wear out over time and so forth, how is it that you can, explain the condition in which all of the rooms, each and every one of the units, is in some level of violation, and many of these, hinges and so forth. There's some pretty serious things in here. I don't think you'd want to live in those conditions. I know I wouldn't. So I guess I'd like to give you an opportunity to respond. This is a serious hearing today, but the violations are pretty serious, Abraham.
Yes, sir, absolutely. For the various serious violations, as Ms. Powles-Mays did mention, they do require a building permit to fix. So it's not as if we can go in today and make changes to the electrical panel. That actually triggers another violation, like work done without permit, things like that. So for a lot of the large systemic changes, like, we do need to have plans reviewed and approved before we can begin work.
I'll just give you one example off the list. Talks about a toilet in one of the units that apparently the toilet was broken, so the repair that was made was, rather than replace the toilet, duct tape and cardboard. That's not acceptable. I mean, you wouldn't do that in your own home. I wouldn't do that in my home. And so I guess that's the type of thing when I look here, beyond what doesn't require a building permit to do that. Whether these occurred a day before or a year before the inspector showed up, it's indicative, though, of a long list. Some of them are systemic, but I see some of these are just general maintenance. If somebody moved out of a room, before you were to rent it again, you think you want that in good repair. It doesn't mean you're going to replace the roof in order to rent it, but some of these things are pretty common sense, Abraham. And I know this has been a struggle, but on the other hand, when I read this, and this, I haven't inspected the property myself, and I'm not licensed to do that, but when I see these things, but I also then when I talk, and you said the pest inspector didn't find any presence, but I mean, it's noted throughout here, both cockroach and bed bug infestations. Now, even some of the best hoteliers probably have to, work real hard to make sure they're, but those are types of things where this isn't like people, are just, living there for free. This is a business. And again, I'm not lecturing you as much as I'm just pointing out that as I've weighed this and certainly thought about it, and I'm very familiar with, this part of my district, is that I get it. You buy an older property, and it may have been in a poor condition, but I don't see where there's been over time a concerted effort beyond making a permit application, and things have gotten older. That roof is the same roof as when you bought it 3 years ago, I trust. But then some of these units, the unit stuff, those are normal type maintenance. If the wall repairs weren't completed, well, why weren't they? I mean, I don't know who's managing the property. I don't know if it was you or sister or your father or whoever, but that's really not the point. The point is that there's been a long list of violations. Some of them related to calls for service, some are related to business licensing conditions, but a lot relate to the property and what sort of condition it's in when you rent it to folks who are, lodging there. Now, they may cause part of the damage, but that's part of the risk of, being in that business. So I don't know if you have anything you wanted to add. I just wanted to give you an opportunity to add, because when I read through this most recent list, acknowledging obviously some of the efforts have been made to reduce calls for service and so forth, I see a property that's in very, very poor condition in a lot of respects. And when the building inspector says it's substandard and it's a public nuisance, that concerns me, because it's your property, you own it, or your family does, and yet we're renting to the general public, and they're the ones that are occupying those units, and I'm concerned when I see those conditions. And so, and some of those safety, when you get electrical permits and so forth, and exposed wires. So I don't know if there's anything else you wanted to add, Abraham.
I'd also like to point out, for an example, we have been working with Mr. Parker addressing specific conditions. So not only are we making the corrections, we've also agreed with Mr. Parker on like a plan moving forward. For example, there's a disagreement on whether there are pest infestations, but we will be doing monthly inspection / pest control, right, as part of this plan. So it's not just addressing each of these points, but also making larger system improvements.
Well, just want to ask you on that point then. So this prompted you to reach out to a pest controller. Had you contemplated doing that before the county ever scheduled this hearing? I mean, again, good management would say that whether you're living there or not, that it would just, good property management would say that, when you're having a turnover of folks, that you would have regular pest management. You shouldn't have to be told by the county or by anybody that if there's an issue out there, you want to prevent that. So have you had that regularly for the last 3 years, or was it just when somebody complained and then, I mean, I don't know. I'm asking you the question.
Yes, sir. I believe we have had it regularly, but maybe not at the interval that Mr. Parker felt we should have been doing it.
I'm going to ask you a real frank question. You don't have to answer this.
Yes, sir.
Would you yourself want to stay for any period of time in those rooms that you're renting to other folks?
I wouldn't be able to answer that, sir.
Okay.
I don't live or work in the area.
No, I know, Abraham, but it kind of goes to the suitability. And the only reason I asked that, it wasn't a trick question. I asked that because it goes to the suitability of the place that you're renting for folks that may not have a lot of means, and they may do damage to property, and and that's objectionable, and certainly it's tough to when somebody pops a hole in a wall or so forth. But it's the conditions by which people live in, and again, this is a business. You're renting that to folks, and that's why I asked the question again. I didn't, it wasn't to try to trick you, but that to me becomes a level by which I think we need to think about this, and I'm certainly framing my thoughts around that as well. Is that what sort of living conditions are we allowing to exist there? So, okay, thanks, Abraham.
Thank you.
That's all I have.
You'll have to ask.
May I make a quick statement?
Sure.
My name is Akash Law with Law Real Estate and Development. I'm currently negotiating right now with the seller of the project. I've poured tons of hours into this project, understanding the problem, and frankly, you're correct. I mean, is the hotel or motel substandard? It is. And personally, they're a small business. They're definitely probably overwhelmed. They need several different trades to get this done. I'm a general contractor, and I mean, the units do need to be revamped. But I think that there is a win-win situation that can come out of this. I'm currently working with the Department of Human Assistance and Volunteers of America to try to help house people that maybe need emergency support services or need affordable housing. There's definitely some land in the back that might have some opportunity. But what I would like to discuss or bring to your attention is what type of win-win situation is their option. So if their hotel motel license is revoked, what does that mean? That a buyer cannot have a license reestablished, or that can be reinstated? I've talked to the planning committee. There's no option really for apartments unless you go through over a year rezoning process. So how can we work together to create a win-win situation?
Well, correct me if I'm wrong, June, but you answered that question already. They could fix all of the violations, bring it up to code, address all these issues, and then reapply for a business license.
Yes.
Yes. So, I mean, I guess I don't see the difference if,
Sure.
if this appeal is not successful and the business license is pulled away, and you buy the property, you're gonna have to do the same thing anyway.
Reapply for the license.
Yeah,
The licenses are not transferable.
right. So your situation's not going to, I don't see where it's gonna be any different one way or the other, to be honest with you.
And I think that another issue that should be taken into consideration is that, given that area and it's close to light rail, is this hotel more safe or less safe if it's vacated?
All right.
That's all. Thank you.
Okay, thank you. Mr. Cerna.
Thank you. So I had a question for June.
Fill out a speaker card. Look behind you.
So my question is this, if, it is this board's discretion, right, to grant the appeal or not?
Yes.
You've given a very strong recommendation not to do that for various reasons. I guess I want to know from our attorneys, what is this, if we were to grant the, what the appellant is asking, what liability does that open up the county to for the next appellant that says, wait a second, they got special treatment, they were in violation for a long time on for a number of different reasons, and you gave them a break. We want the same discretion applied to us. So what kind of liability do we assume, even if we wanted to grant the appeal? We should know that. The public should understand that.
Well, first of all, you're setting a precedent. If you do grant the appeal, and you will, I'm sure, have other appellants do just as you suggested and say, well, you did it for Casa Linda, please do it for me. There is a certain amount of responsibility that is attributable to the board when you have the opportunity to ensure that a business is complying with the county codes and you decline to do that. As far as the details and the level of liability, it varies, but certainly the board does subject itself to potential complaints and liability if it allows substandard buildings to continue to exist after a hearing wherein it has been brought to the board's attention and the board has had the opportunity to stop it.
Yeah, and I don't see it just that way. I see it as we'd be cherry picking, right? We'd be cherry picking the winners and the losers, and that seems to fly in the face of the principle of, equality under the law. Everyone should be treated similarly here, and we're not a court, but I have a real problem with what you just alluded to in terms of the precedent that this would set. Because then we get this board into the business of playing favorites, quite frankly, and that's not of interest to me, and I don't think it's necessarily the business of this board to commit themselves to. So I'm not going to be supporting this. I'll let others make motions, but that's my perspective on this.
Supervisor Natoli.
Yeah, maybe Jim, while you're there, as it relates to if the denial revocation is upheld today, then is there an appeal period beyond the board's decision here? I assume it can be appealed into the courts. But at what point would they then be required to no longer occupy the premises, at least for the purposes of a motel? I guess if you have a caretaker's quarters there, someone could reside there to assure the property was secure. And in the event that that was the case, and whether it was the gentleman that spoke a moment ago or someone else came in to do a renovation or to reoccupy, would, before a business license could be reissued, would we require that all the code compliance issues be addressed so that if a new operator, a subsequent operator came in and there was no business license, would that be a condition, or would that be a finding that we would make that said you couldn't just, you rent it while you're fixing it up, so to speak? So kind of two questions there. Okay.
So the decision of the board becomes final when it is filed with the clerk and served on the appellant. And if the board decides to deny the appeal, then the revocation would be effective at that time. When the revocation is effective, the business must stop operating. The hotel cannot rent rooms any longer to patrons. As far as a license in the future, Laura Jacobson could probably speak more to that issue, but just as an overview, there absolutely would be the expectation before any new license would be issued that the old code violations, zoning violations would be corrected.
Okay, and just to follow on to the first question, when the revocation will become final, the motels, hotels are daily rentals. Some folks do weekly and monthly rentals. In the event that were to become final, is any relocation of existing tenants in the event that they had a longer term or return of them of the daily room rental? That's the responsibility of the property owner, and so the premises can be vacated immediately. And would it also cover, as I know there's concerns about squatters or others that might move into the property if it were vacant, but you're not going to, but you can't live, people live there for free either, right? There's no coloring of this picture so that you can say, okay, well, they're not paying anything, they can stay there. That's not how it works. Is there a requirement to secure the property? And if so, what's that look like? And is that a part of the order if the revocation is upheld?
So yes, there would be a requirement that the property be secured, lest it become another nuisance. As far as the occupants that the owners have been renting to, it is their responsibility to address whatever contracts or agreements that they have made with those people as far as how long they'll stay in the room. I also neglected to say that if the board denies the appeal today, the property owner can file a writ in Superior Court, but during that time, the revocation remains in place unless or until it is reversed by the Superior Court.
Okay, so the revocation is equivalent then to immediately vacating the property?
Yes.
And how is that enforceable? Who enforces that?
Guys with the badges.
Okay, sheriff. Okay, so the sheriff's department would post the property, and then there's not an eviction process. Basically, it's a daily rental. So.
And the notice would be served, of course, on the property owners.
On the family, or whoever, or the corporation. Okay, thanks.
I have one for you. So they've had their license for 3 years.
Yes.
When they got their original license, was there ever any inspection done, or do we know what the condition of the premises was when they got their original license?
I'll let Laura Jacobson from Business Licensing speak to that.
Okay.
Good afternoon, Supervisors. My understanding is the license was issued in January of 2016, and at sometime that spring, there was the original code enforcement case that was opened by Mr. Wycliffe, and that was a case that was just recently closed. So that case was open for nearly 3 years.
Okay. All right. Thank you.
You're welcome.
So I thought what you were asking is when the motel any motel gets a license, is there an inspection that it's habitable?
No.
Right.
Okay.
Okay. I do have a couple of cards here. If the board's done. John Lee.
I'm the listing broker for this property, and I just have a gut feeling that if it does get revoked, there's a record that says it's revoked, so it might be an onerous task to go through the standard process to renew, for the next buyer to renew, get a business license. Is that correct? It's not a simple solution of, the next buyer to simply get a new business license to apply for it. But when they see this as a record that was revoked, it becomes a more onerous task to get the business license for the next owner. Is that correct?
Yeah, but it's really not the county's problem.
Well, I don't think it becomes more onerous. I think that to the questions we were asking a moment ago, with that, whether there was any inspection done at the time of a transfer of property, I think what this does, if in fact we uphold this, is that it sets a marker saying that at this point in time, the property was in this condition. It doesn't say you can't get a business license. In fact, anybody who would buy, whether it was you or the other gentleman or somebody else, would have to get a business license, not transferable. But since we don't do inspections, even though we had outstanding code violations, I think what this would effectively do, though, it's going to stop folks from renting those properties that are substandard. And I'll be very honest with you and everybody else in the audience here today. That concerns me, those conditions out there.
Right. I mean,
and so you draw this line that says you got to do the repairs.
Right.
To get your
Just working backwards. I mean, if I can visualize this next owner is probably chance likely to be more qualified to run this and know that they're getting into. Well, in fact, even working back further, this property has been in contract for about 5 times or so because they were scared of the fact that this business license is going to be revoked. And I'm just wondering if it's an issue at all to say, let's say it's revoked and it's on the record that this motel is revoked. And I tell the next owner, well, you can just simply apply for another business license, just like any other.
Well, you'd have to clear the code enforcement
Yeah, as long as you
violation.
fixed it.
Okay.
Like I said, it's not our responsibility, that's the property.
I know it's not your. It's just what is in the mindset of this new owner.
They'd have to make the corrections, Mr. Lee. They'd have to make the corrections.
And would there be a big loss in having this license revoked on paper saying it's revoked versus this new buyer buying this motel?
Not as long as the repairs have been made and all of the violations cleared. It's not. There's not going to be prejudice against this property having a business license moving forward, provided that all of the codes or all of the code violations are fixed.
Because I don't know what the big deal was of all these buyers getting into this property and thinking about the risk involved with the potential of this business license being revoked. But in fact, they would have to anyways apply for a new business license in any motel.
Right.
So I don't know what the big deal is and why this buyer is scared and canceling.
Well, you'd have to ask
contract.
him.
Yeah.
Well, they're telling me.
Keep on saying,
They'll
it's not in our corner.
Well, maybe the condition of the property.
Yeah, have you read the report?
Again, Casa Linda is what? I know it's been there at least 45 years, maybe 60-year-old property.
Okay.
It hasn't always been in disrepair. But that, looking at that, and then I think people might be more worried about, I could be wrong, not so much the status of the business license, that's a pretty normal transaction. It's what they're going to buy in order to have to repair and fix the property to get it up to some acceptable standards. I'm only guessing, but it seems to me that might be what worries folks.
The challenges of being
absolutely.
able to not have control of what the county will approve based on what the efforts that they will put in applying for this business license. They'll have to meet certain code requirements that they seem to not have control over because it's up to the county to approve or not. This is what I'm getting for a lot of these buyers, and they're.
Well, it sounds like you might have more inexperienced buyers.
No,
approaching
I have buyers who've owned the motels in the area, just
Then
like
maybe
a
it's a
mile.
price negotiation.
Is it what?
Maybe it's a price negotiation.
The advantage you have is that you have a complete list of everything that needs to be fixed.
Okay.
So you know what the path to the license.
The consequence of this makes it more difficult. We understand it makes it more difficult to have a transaction that follows it, but that's the consequence of not following the rules and not having your property meet code. I can't put it more simply than that.
Yeah, I think we understand where you're coming from.
Okay, well, I'm just trying to communicate what these buyers are telling me. There's a risk involved if you have something on record that you have to apply for new business license and the element of meeting up to code. I think there's a risk in that.
Which they're going to have to do anyway.
It's a rule for everyone.
Yeah.
versus another motel that can buy where it meets up to the code standards, which is an easier transaction for
It's
these
the one.
buyers. Okay.
Yeah.
All right.
Okay.
And if I could just offer that, again, you have representatives in the audience today of, the neighborhood association out there, and certainly this property along Folsom Boulevard, as you probably well know, we're putting significant monies into the public infrastructure along Folsom Boulevard because of its proximity to light rail, because of the need to bring street lighting into the area and to help with mobility. And so I think there's an opportunity to complement that. And I know that the church adjacent, obviously, that property has been under renovation. They've done some major investment there. The property to the east has been challenged, although my understanding is that they've done a better job in managing that more recently. And so I think there's some really opportunity along that north side of
Yeah,
Folsom.
there is an opportunity, and I have a gut feeling that Castle Linda Motel may have even a better use for the buyers, but they
Right.
would like to be able to lower the risk level. And we have some really good buyers who step up and want to keep it in the
If you
area.
have future buyers, as the representative of the district, I'd be happy to, call together the right folks, whether it's, trying to make the corrections and or other uses, certainly whether it's zoning and so forth. Again, some of those are, require, different entitlements. But I'm more than willing. I'm very interested in seeing upgrades to that segment of our county, but certainly of Folsom Boulevard. And I think we've got some good things going there, but this could be a compliment rather than a detriment. So,
And I know what they're up against. This revocation could be a challenge for a lot of buyers, and to the extent that not only will they see the risk involved, contrary to what we talked about as consensus, but also there might not be any more interest in developing further than this with that license revocation on record. And we might even see, to the extent that not only will this be a vacant motel, but it will be vacant. I mean, the land value, I was told, is about $800,000. I don't know even if a buyer would go to that extent to buy at that low price with this revocation and the risk involved. I'm just visualizing what the end result will be next year when this follows through to that extent.
Okay, I think at this point your question and issue has been asked and answered. We hear you, we understand where you're coming from, and I gave you a lot more time than we normally do speakers. So
Okay.
I'll call the next speaker.
Thanks.
Linda Hammett.
Hi, Linda.
Hi, good afternoon, speakers, supervisors, and thank you very much for allowing me the time to speak. My name is Linda Hammett, and I represent the Butterfield Riviera East Community Association, which is the neighborhood association of which the Castle Linda Motel is a part. Many of our residents are adjacent to this motel. I am here to support the denial of the appeal for the revocation and the renewal of the business license. One of the things that we've observed in the community is the repeated pattern of behavior and the inordinate calls for service. I did send a letter to the board, and I thank you for including that in the materials. We are very, very concerned the repeated violations and as I said, the pattern of behavior where these violations, when they're brought to the attention of the owner, yes, they may go ahead and remedy those violations, but then more violations will crop up, and this seems to be a pattern over and over and over. I'm concerned about the health and safety hazards for the surrounding community, not to mention for the residents of the motel themselves. Residents of the community have observed so many scenes of illicit behavior, which are documented in the various community agencies. But one thing that struck me as I've read through the materials and as I've listened to testimony here is the lack of proactivity on the part of this particular business owner. Now, for myself personally, I am strongly proactive of small business And I applaud the county's repeated attempts to work with this business owner. And I thank you very much for those attempts and for allowing the business owner to try to remedy this. But this has gone on way too long, and no remedy seems to be sufficient. I would encourage the Board of Supervisors to deny this appeal. It seems that nothing will satisfy
Can you
this
wrap
point.
up?
Thank you very much.
Thank you. That is the last card I have for public comment. Nobody else? Okay, then we'll bring it back to the board for discussion. Actually, Don, before you do, I do have one question just for clarification. I'm missing something here. According this business license we have in our packet shows that the business license expired in January 24th. So in essence,
They're closed now.
It's a revocation and a denial of the new application, I believe.
Yes, while the expired license is under appeal, it's still in effect.
okay, all right, thank you.
Yep.
Mr. Natoli.
Thank you, Mr. Chair. Well, thanks, folks, for being here today. Obviously, a lot of work's gone into this, as I think Krista summarized in her opening comments about this, and certainly, it's never easy when you have a matter before you that you know is certainly going to impact the business. But I think that business has obviously been impacted over the years, and albeit maybe with certainly some efforts to try to bring it into compliance. It appears to me that in a lot of respects, not only have they fallen short, but again, as I've stated here earlier when Abraham was at the podium, that it concerns me greatly, certainly for as noted, the health and safety issues here, and the ones that relate to not only the occupants, certainly to those who might own or manage the property, but also to the adjacent residents. And certainly, I don't, relish the idea that we may have a vacated and I won't say abandoned, but a vacated property. That's not a real pleasant presentation either. But I think at this point in time, with the information we have in the determination by the hearing officer, with the most recent inspections, and certainly I think just the history, which has been pretty checkered, to say the least, and that may be being generous over a number of years here, that I think the opportunities may be presented here for this or new owners to take a look at this use and the condition of the structures on the property, and the physical improvements that would have to be made and the cost of those. All of those need to be taken into consideration. But I see no ability at this point in time, and no reason why we should do anything but sustain the hearing officer's decision. We've taken into account the testimony here today, and so with that, I would move the staff recommendation, which is to deny the appeal, and to it would be, I guess, to revoke the business license and deny the renewal of the general business license for this property.
Second.
To
Yeah.
add in the additional condition that Ms. Powles-Mays had recommended, which was that we had to add an additional finding that as of June 18th, today's date, appellant remains in violation of condition K, maintaining operable telephones in all guest rooms, and condition M, maintaining the premises and guest rooms in compliance with county code enforcement and building requirements. So that would be added as an additional finding if the board so chooses.
Sure, I would add it in, and I think that to the point being made here that obviously this has the attention of many different county departments, but that in the event that either the current owner and/or a new owner would express interest in re-inhabiting the property, that we make sure that we have all the proper checks and balances in place, Krista, to assure that this owner or any new owner before that property would be reoccupied under this decision, that they'd have to make the necessary improvements. I heard that stated, but I think that needs to be enforceable. And I don't know anything we do here today to make it any more enforceable, but I think that's very important. But I would add what you stated.
Second the motion with those additions.
Okay, we have a motion and a second. Please vote.
Unanimous vote.
All right, thank you, board.
Thanks.
We're on to county executive comments.
No comments.
It comes from the board.
I do. Okay, thank you. I'd like to ask the county executive to look into a ban or something close to it on flavored non-cigarette tobacco products. Recently, the Sacramento City Council had an ordinance that addressed this issue, and I think it was a good move, maybe not strict enough, but in addition to being a health hazard for youth and adults, it's from an enforcement standpoint, when something gets banned in the city of Sacramento, it moves into the unincorporated county. So I'd like to avoid that, and but mostly keep youth from getting involved in a substance that leads them into cigarette use as they get older.
Okay, we'll do that.
Okay, anything else? Nope, we're adjourned.